YSL trial is getting crazier and crazier by the minute. After the judge found YSL attorney in contempt and jailed him, the prosecuting attorney asked that he be returned to the courtroom for the sake of the trial and not miss any of the hearing in order for him to represent his client, because then it would have been good grounds for a dismissal of that case. The reason YSL attorney was jailed is because he was privy to information that only the judge, the prosecutor, and a key witness was privy to. And the judge asked him, how did he come about the information? And he refused to answer. The judge gave him a substantial amount of time to think about it before he was found in contempt of court. Here is the prosecuting attorney laying out the argument on why he should be returned to court.
We would ask that the court fashion a punishment for the contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels. For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not affect his ability to have his counsel of choice represent him during this trial.
So there are all kinds of moving parts in this trial. Later on that day, around 7 p.m., mind you, Ashley Merchant showed up because she was representing Mr. Steele, attorney Brian Steele, who was hauled off to jail, or at least was in a holding cell. They had brought him back, and Ashley Merchant laid out her argument why he should not go to jail and he should have his day in court if the judge is going forward proceeding with the same argument that he's in contempt.
Judge, just for the record, is the criminal contempt, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
No, with criminal contempt, I told him what the contempt was, and that was he refused to order the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Okay. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
and Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And notice of that.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
well, and okay. Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you're a witness to the proceeding.
So guys, you see how complicated this matter is getting, this case is getting. The judge did find him in contempt, and he's going to have to serve on a weekend jail time until the end of the year. I believe it's August, he said. But no doubt they're going to take this further to a higher jurisdiction to get this all thrown out, because he does have to represent his client and be in the courtroom also to prepare adequately for the next time he goes to the courtroom in order to properly represent his client. So this is not over, not by a long shot. I believe Ashley Merchant is going to file that appeal. And for a lot of us, we know who she is already. She is involved in the Donald Trump's trial out there in Fulton County, Georgia, with DA Fannie Willis spearheading that investigation.
Mr. Steele, I am going to hold you still hold you in summary criminal contempt pursuant to OCGA 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody and incarcerated in Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m., subject to further order of this court.
So Attorney Steele proceeded to take his jacket off. He took several things off. I believe his jacket, his tie, and he made a statement to the judge. He requested actually if he and the other attorney working on the case can visit him on a weekend in jail and work on the case further, because everyone knows that attorneys don't have a day off really. They work on the case constantly on a weekend, during the week, at night, weekends, etc. The judge said, no problem. Your request will be granted, and then he was taken away. I think they had him in a holding cell, and he said he will be spending the weekend down there at the Fulton County Jail every weekend until the 18th of August. Now, if there's a change in that ruling, it will all be dependent on him, whether or not he comes forth and tell the judge who told him that information, or if there is an appeal on the judge's ruling, and the judge ruling to reverse that judgment in the appellate court. Before Attorney Steele was taken away, he had a request. Let's take a listen.
Can I ask a question? Sure. I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you, and sir, I will. Sir, if that comes to pass, you have my support. I will talk with our sheriff, and we may be able to make that work. Okay.
That was the biggest highlight this past week in a YSL trial.
After a back and forth that delayed day 88 of the Young Thug, YSL RICO trial, Judge Ural Glanville upheld his order to hold attorney Brian Steele in criminal contempt and said he would have to report to the Fulton County Jail every week for the next 10 weeks.
But here's a little recap by Crime Fix on the interaction between Brian Steele and the judge, why he was ordered to go to jail.
Mr. Steele, I am going to hold you still hold you in summary criminal contempt.
The judge in Young Thug's RICO trial orders the rapper's attorney to jail for contempt.
Now, how did you get that information supposedly from my chambers? Did somebody tell you? You should have told me. You got 5 minutes.
This happened after lawyer Brian Steele refused to tell the judge how he found out about a meeting between the judge, the prosecutor, and a state's witness. Steele's lawyer is here with what's next for him and Young Thug's trial. I'm Anjanette Levy, and this is Crime Fix.
So they really were at a stalemate because the judge wanted to know, how did Brian Steele, attorney Brian Steele, got his information? Who told him? And attorney Brian Steele wanted to know, why was he and his client not in the meeting? Because in a trial, if there's a meeting, everybody's supposed to be there. The prosecutor as well as the defense lawyer. So he wanted to know, why was he and his client excluded? Was there a deal done behind the scenes? It's very suspicious. And so I guess only an appellate judge can iron this out, because clearly Ashley Merchant is going to file that appeal. But here is the back and forth argument between the judge and attorney Brian Steele.
For the record, if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based on information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that court reporter at times, court at times, district attorney or district attorneys for the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never. Mr. Joe, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. If all that was an ex parte conversation, how did you find out about any of that? Well, I'm disturbed too. And the reason I'm asking you a question. How did you find out about it? I'm going to ask you the question. Okay. Scuttle, if you look at SCUDDER versus State, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based on what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's the critical stage. It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record. Well, I'm going forward. What I was told was that Mr. Copeland said, and you haven't answered my question yet. I'm not. How did you answer that question? You're not? No, I will not answer that. Why will you not answer that question? Because I want to make sure that what I say is accurate, and I'm not trying to... No. I'm asking you, how did you get this information? I'm not telling the court. What I'm saying is based upon information. Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems. We can have this. I have problems right now. Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with the party. I mean, a witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court was asked me, Copeland, tell me how you got the information. Listen, tell me how you got the information, then we can go ahead and go forward. I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court. It concerns me that you have proprietary information or information that you should not be having that was ex parte. Why? With a party. Why? State of Georgia. How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did. Mr. Steele, I still want to know, how did you come upon this information? Who told you? What I want to know is, why wasn't I there? Why, sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was coming from. Well, I'm not answering that question. That's attorney-client privilege information. I am not attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out. I tell you what, I'm going to give you 5 minutes. If you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege. Attorney work product privilege. I am not. How did you get that information supposedly from my chambers? Did somebody tell you? I'm not. You should have told me. You got 5 minutes. Well, I don't need it. I want to continue. This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas. Don't take my notes. No.
The conversation was really spirited. It was heated. And you can see both point of views. The judge wanted to know who told him. Is it a plant in his office? Because if there are only a handful of people in the office, preview to that conversation, who leaked it? On the other hand, the defense attorney wants to know how come they were not invited to the party? How come they were not in the room when those conversations took place and they were supposed to be? So this thing is going straight to the appellate court. On that note, I'm over and out. Don't forget to hit the like bell and subscribe to the channel if you haven't done so as yet. I'll see you guys on the next one. Thanks for watching.